First call, second call, third. All right, folks. We've had a great day today. The morning and the afternoon, we kind of focus between the tensions, the tension between multi-stakeholderism and multilateralism. A lot of this countries versus civil society tension. We have a different subject to us today, but very, very relevant subject. And it's a treat. It's a good friend, Hiram Mendenez. Hiram is a colleague, a fellow attorney. We've had some collaborations in internet-related human rights and information issues. He's one of the leading, perhaps the leading Puerto Rican internet law attorney from our generation, very proud to say. He's a full professor at UPR School of Law on all things cyber law, intellectual property and constitutional law also. He also teaches law in the University of Ottawa and the Levin College of Law in the University of Florida. So with no further ado, please a hand for Hiram Mendenez.
Hi, I apologize. Can we have this?
I can turn it on for you if you want to. And then the pointer right here. Problem they had earlier.
Okay, thank you so much. And thanks for the organizing committee of NASIG and specifically to Javier Rua. He said, we're all friends and it's great to see him again. And thank you for all those half-truths about me. So, okay. So what are we doing today in this presentation? We're going to talk about, so I'm an IP person. I'm also a constitutional law person, right, at the University of Puerto Rico. And I usually, in my work, I try to blend these two things together. So I am very much concerned about individual rights in the online environment, particularly freedom of speech. So in the copyright context specifically, we see in the online world a lot of intersections between IP and freedom of speech to the extent that copyright or the use of intellectual property or the use of copyrighted content sometimes involves people's interest in expressing themselves, and this is something that also we will see expressed in this presentation. So we will be talking about intermediaries. And another way of approaching this problem is through the concept of gatekeepers. Right, so you remember in the 1990s when the internet was more or less became very popular, right? And in the let's say for the consumers, for regular consumers, right? Early 1990s, CompuServe, dial-up connection, things like that. What were the main concerns of policymakers at that time? Yeah.
Policymakers at the time regarding the internet.
Yeah.
Hackers, cybersecurity issues.
Right.
Control.
Control issues. What?
I'm going to disagree.
Right.
Since I was there.
Well, you were there. Yeah. I forget the
Sorry, my name
audience.
is Marilyn Kay, but the main concern of policymakers at that time in the narrowband internet, remember there were so few users, and the internet computers were coming into the home, and it was exposure of children to information, content, that parents were not familiar with the internet or with the computers, teachers were not familiar, and kids were chatting in chat rooms and being lured. So that was one of the scariest times, I
That was one of the scariest times, I think, because there was this great overreaction to how risky this thing could be.
Right. Particularly porn, right, in the United States. Let's put it in those like very clear terms, right? So in 1996, for those of you who know about this stuff, the Congress, the United States Congress approved the Communications Decency Act, which was mostly struck down as unconstitutional by the Supreme Court of the United States on freedom of speech grounds, to the extent that, well, and this is like a little, side conversation. In the United States, adults have a constitutional right to use and express pornography, like sexually explicit content, to the extent that that content does not cross a line towards obscenity. So obscenity can be forbidden, but pornography or sexually explicit content cannot be forbidden to adults in the United States, but it can be regulated with regards to kids, to children, right? So you can regulate it so that children do not have access to it, but you cannot forbid adults to do it. So the Communications Decency Act, approved in 1996, sort of like tried to tackle the problem of porn for kids and in general, but it did it in such a way that the Supreme Court found it offensive with regards to the First Amendment and freedom of speech rights. At the time, when the Communications Decency Act was approved, John Perry Barlow, who you might know about, who actually recently passed, died, I think a month ago, exactly a month ago, right? John Perry Barlow wrote this piece called the Declaration of Independence for Cyberspace. You know that one, right? Government of the world, you weary giants of flesh and steel, I come from cyberspace, you can't touch us for where we come from, or something like that, right? So the general idea, from that time is that, whatever happened online sort of was outside of the reach of governments, right? And that was like the cyber utopia, I guess, ethos of the moment, that whatever happened online was impossible to regulate from like normal traditional brick and mortar governments. Today that we know that that's not true. To an extent, right? Today we know that online activity or whatever we do online can be regulated through law and can be regulated in multiple ways, right? The copyright or intellectual property, scenario is similar in that regard. When the internet became so popular in the 1990s, I guess if the first thing that was worrisome for policymakers was porn, the second thing that was worrisome for policymakers was piracy, right? You remember the whole Napster context, right? People downloading a bunch of music things, which obviously still happens today, but it was shocking for the content industry. It was shocking for music industry in particular, right? Because at the time we were talking about dial-up networks, so there was no like music download as it is today, right? So it was principally music. The main strategy for content owners to tackle piracy or intellectual property, appropriation without permission, at that time it was like twofold. On one hand, you had a big strategy to go after the downloaders themselves, like users, the kids that were downloading a bunch of things in Napster. Another strategy was to go in court against Napster itself. The Napster strategy worked at that time. It worked to the extent that they could take down Napster at the time, right? And Napster like remorphed and did other stuff. The strategy of going against the user, it's problematic for many reasons. There's a whack-a-mole problem, right, on the internet, right? There's like so many people doing so many things that you can get this one kid in college who's downloading music, and maybe you can threaten that person not to do it again, with the hope that that will create some sort of deterrent for the next person. But it is just so massive and pervasive that you just can't do much about that by tackling all these people. After a long time, the litigation strategy against users, it became evident that it was completely useless. Not completely, but mostly useless, or too costly as well. Like, you know, attorney fees and the effort, and then also the, it was costly in terms of how it was perceived by the public. Like, you know, big content industry against little people, right? So what they learned at that time is that, contrary to what John Perry Barlow expressed in the Declaration of Independence for Cyberspace, is that you could actually try to regulate online behavior by tackling not the end user of the work, but by tackling intermediaries, right? By tackling and trying to target, legally speaking, target internet service providers and other online service providers, to try to recruit these institutions that sort of facilitate individual behavior and recruit them in the effort of policing the usage of intellectual property. And this is what we're going to talk about, right? So multiple ways, and the legal regimes that sort of allow, or that establish a framework for dealing with intellectual property use, unauthorized use, or piracy, if you want to call it that way, but not directly against users, and instead recruiting online service providers. So this is what the economic literature and, you know, people who write about this stuff, these institutions, they're sometimes referred to as gatekeepers, right? This is why I have a bouncer there. Also because it looks intimidating, and I want to create that impression. I am succeeding, I see. Okay, so gatekeeping regimes are everywhere, right? Not only in the online environment. In the offline world, and not even in the IP world, in the offline world you see gatekeeping regimes. You know, the law uses that strategy a lot. And you can think about a bouncer, right, at a bar or something like that, right? One of the functions of a bouncer at a bar is to make sure that young people do not get in, because, you know, the bar might be liable if they sell alcohol to minors. So of course it would be, I guess, it's inappropriate or maybe illegal for a minor to drink alcohol. But one way to make sure that that doesn't happen, that the kid does not use alcohol, is to make liable another person for the behavior of the minor, right? And this is the strategy that's used. Sometimes these strategies are like just like bouncers, like asking you for an ID. Like, it's a very simple obligation on the part of the bar, which is like, give me your ID and I'll sell you or not something, or I'll let you enter or not, just by asking for an ID. That's what we call bouncers, right? In the lingo of gatekeepers, because their obligation is very sharp, very narrow. It's on and off, binary, right? Sometimes we'll see that when we see the notice and takedown regimes in the copyright context. Just like, I send you a notice, I'll just take it down. No questions asked, that's it. Other times, instead of bouncers, we have intermediaries or gatekeepers that have the shape of what they call chaperones. A chaperone is a different sort of gatekeeper, right? It's not an on and off position. It's like someone who's there and tries to carefully calibrate what is going to happen as things go along. Sometimes these intermediaries will behave like chaperones. Like, for example, in the concept of the bar as well, that in some jurisdictions, when a bar sells too much alcohol to someone, right, and that person gets drunk, if that person then causes an accident while driving drunk, the bar can be liable for that accident, right? So then the bar and the bartender has an incentive to sort of monitor more carefully how many drinks am I selling you, and to see if you're tipsy or not, right? In that kind of scenario, the gatekeeping regime is not that sharp as in the bouncer case. It's more like a chaperone. Right? So we see these sort of models of gatekeeping regimes in the online world, especially in the copyright context, and this is what we'll be looking at. So let me tell you, so let me start somewhere with regards to like the legal regimes that are out there. The first place to start is with the WIPO Copyright Treaty of 1996. Okay, I am told that you will have this presentation at some point, so take it easy with the notes there. So the WIPO Copyright Treaty of 1996, again, note the date, right? 1996. This is an important context. It establishes, so this is an important copyright treaty to the extent that it sort of tries to update international copyright regimes to an online world. And one of the rights that it talks about is the right of communication to the public, which essentially means that authors and owners of intellectual property of copyrighted content, they have a right to themselves communicate to the public the work. And they also have the right to authorize others to communicate to the public their work, right? So this is what it says, right? Authors of literary and artistic works have the exclusive right of authorizing any communication to the public of their works. This is what it means. So suddenly, when you phrase it that way, ISPs or other online service providers start to worry and say, wait a minute, when someone uses my facilities, right, my services, is it going to be interpreted that I am authorizing them, those users, to communicate works to the public? Let's say someone uses, if someone uses my platform for, communicating to the public copyrighted content without permission, am I going to be held liable to the extent that I am authorizing that person to do that, right? So that is a big question which the WIPO Copyright Treaty does not address it, except that in a note, you see there's a note 7, right? It says, it is understood that the mere provision of physical facilities for enabling or making communication does not in itself amount to communication within the meaning of this treaty or the Berne Convention. What that means in non-legal terms is, what we've just been saying about the right of communication to the public cannot be interpreted in itself to mean that someone, just because someone is creating a platform or providing services for people to communicate, if someone else shares copyrighted content, that the mere fact that I am providing the services to do that does not make me liable for that. But it just creates a lot of murkiness, right? It just doesn't address the problem. This is just to point out that this is sort of one of the first places where this problem of the potential liability of internet service providers start to come up. So what happened after this? This is what happened after this. Sorry, this is a small font, right? At the top there, you have the Digital Millennium Copyright Act of 1998. This is a U.S. law. And within the DMCA, this is what we're going to call it, Digital Millennium Copyright Act, DMCA. Within it, there's the Online Copyright Infringement Liability Limitation Act. Forget about all that stuff. Let's just talk about the DMCA of 1998, right? This is a U.S. law, and we're going to talk about the DMCA in a couple of minutes. This is a U.S. law, 1998, that tries to establish a framework of what are we going to do with intermediaries, with the gatekeepers. What will be their responsibilities? What kind of liability are they going to have, right? And the reason why we're going to focus on the DMCA is because it establishes a framework that has been replicated in many places around the world. So in some way or another, you will find around the world versions of this idea, of the ideas established in the DMCA. For example, in the year 2000, you have the Directive on Economic and Electronic Commerce of the European Union establishes a similar framework. The United States has been very aggressive in exporting this framework as well through free trade agreements. Throughout Latin America, for example, this is a couple of examples, right? Free trade agreement between the United States and Chile, Central American and Caribbean countries, Peru, Colombia, Panama, just to give a series of examples, and significantly the Trans-Pacific Trade Partnership that was finished a little bit ago, but the United States, the Trump administration pulled away from it, also enshrined the framework of the DMCA. So this is why it's important to understand what the DMCA is about, because in many ways, what you see around the world developing is something along these lines. So to understand the DMCA, then we have to think about pre-DMCA, legal world. And I know that there's people. I mean, are there many lawyers here? Hope not. You over there? No?
No, we're alone.
Good. Good. I have one of my professional goals. It's counterintuitively maybe for you, but my one of professional goals is to make sure that there are as little involvement of lawyers in people's interactions as possible. Real costly but necessary as well. So let me continue with my talk here. So this is what happened in the United States, and many countries have similar ideas as well, because the general rules of responsibility and liability around the world follow similar concepts, right? In the United States, we have a thing called common law, which is like a set of rules that are being developed by courts, progressively throughout the years and decades in history. In the copyright context, you had certain rules, and you still have them. You have certain rules that have been developed to define when is an institution liable for another person's infringement of copyright law. And let me give you an example. For example, the case of a bar owner. I'm sorry, I keep coming up with bar.
There's a trend here.
So the bar owner that has a band playing at the bar, if the band is playing music that is copyrighted by, like a musical composition, that band is publicly performing in the copyright bingo, publicly performing a musical composition. So the band is, technically speaking, infringing a copyright unless it has permission. Right? The bar owner is not performing that act. So the question is whether the bar owner is liable somehow. And the answer is yes. Right. And you would agree, like intuitively, you would think, what? What's that one?
You employed him.
Right. So we'll see why. But it's something like that, right? The idea is like the bar owner. I mean, you cannot be left off the hook. You basically you can see why that is an intuitive answer. So the way the law looks at this. Let me give you another example, so we can continue on without the examples. Another example would be bootlegging, selling pirated CDs, or music, or videos, or whatever, bootlegging at a flea market, right? Are you from the United States or elsewhere? Flea market?
Yeah.
Okay, flea market. So the bootlegger, like the people selling like pirated CDs or whatever on a flea market. So the bootlegger is liable for his or her own, infringement. But is the flea market owner or administrator liable as well? You may see, maybe yes, maybe not, right? Perhaps yes. So the reason why we come up with those answers in the pre-DMCA world in an offline environment will be because of these two categories of what it's called secondary liability regimes. So on one hand, you have what's called vicarious liability. A regime of vicarious liability means that you are responsible vicariously. Right.
Which means
You are responsible vicariously for the acts of other people when you have the right and ability to control that activity, and also when you receive a direct financial benefit from that activity. So you can imagine why the bar owner is liable for the people that play music. Yeah.
Is this what happened to Kim.com?
Yes. Well, we'll get to that.
Okay.
We'll get to that. But one of the challenges we'll see is that these are all rules, right? These are all rules that are designed for the bar owner and the band playing, right? So what happens when you take that to, the online context, right? But yeah. So when you have the right and ability to control some activity and you benefit commercially or economically from that activity, you can be vicariously liable. And you can see how the owner of the flea market and the bar owner might be liable for those cases. Then there's also another kind of secondary liability, which is called contributory infringement. So contributory infringement is different, because in the first case, you might be liable even if you're not doing anything wrong. You just, because you have the right and ability to control and you receive an economic benefit, you're liable. But in the contributory infringement scenario, and this is the phrasing, right, contributory infringement is telling here, is because you contribute to the activity, right? So look at the phrasing there. If one who, with knowledge, so you have to have knowledge of the activity, with knowledge, materially contributes to the infringing activity, then you can be liable. So what is knowledge? Right? If you actually know that there's infringing activity, so if you're the bar owner and you actually know that these people are singing, and you, right, and then you materially contribute to that, and then you materially contribute because you're providing the platform for them to do it, then you might be liable for their activity. One tricky question is that the concept of knowledge in contributory liability regimes is not only actual knowledge. It could be what's called, like, let's say, constructive knowledge. You knew or should have known that was going on. Now think about these concepts in the early internet. Like, and one of the cases involved, for example, CompuServe. Remember that? CompuServe? Right? So people in a chat room, they're talking about things, and then someone posts a bunch of texts from a novel or something, or from copyrighted content. Like maybe it's not a movie, maybe it's not a song or whatever, but it is copyrighted content, it's text. And then someone complains to CompuServe. So what is CompuServe's appropriate reaction at that time, right? It's copied, so it's CompuServe has to make an evaluation at that moment and say, like, well, maybe, I mean, I know you're not copyright experts or anything, but to define whether there is an instance of copyright infringement in a case like that is not that simple, because someone can tell you that is copyrighted content, but how do you know that, right? How do you know that is actually copyrighted? How do you know you're the owner? How do you know that that person is not engaging in what's called fair use, which is a very liberal sort of doctrines that allow people to use and reuse content as well. So, from the perspective of CompuServe, it is a tricky proposition to say, I believe you, I'm going to take it down, right? Because you also don't want to anger your consumers, right? And take down everything just because someone is saying something. But then what if you're wrong, if you're CompuServe? What if you're wrong in the sense that you decide not to take it down because you don't believe this person, and then you leave it there? That person is going to sue you, and it's going to say what? It's going to say, CompuServe, you are liable, because what? You have knowledge, I informed you of this. And you are materially contributing to the infringement to the extent that you created a chat room. And then, so you, not only that person is liable, you, CompuServe, are liable as well. Obviously, I prefer to sue CompuServe for the deeper pockets. So it creates a bunch of problems for intermediaries, these rules, right? They do. And they create problems also to the extent that then it creates incentives for CompuServe to start to invest a lot of resources in supervising the content and trying to eliminate bad content as soon as possible. So it's sort of like a strange setup, right? The legal regimes that are there, pre-internet legal regimes that are there for these service providers in the beginning. And now you can imagine how that extrapolates to ISPs, for example, right? Would have like millions and millions of users and traffic and all that stuff. Like, what are you supposed to do if you have this sort of like rules in place for you? So this is like the default set of rules. And we're going to examine what happens when this default set of rules encounter the internet. I'm going to jump ahead a little bit. Okay, let me tell you a couple of things before we go to the DMCA, right? The DMCA is the set of rules that try to save the day. That's what we're gonna get to that. Before you go to the DMCA, you should know about a couple of other things in the legal regimes. In the United States, there is something called the Sony Safe Harbor. So what happened to anyone knows about the Sony Safe Harbor? Yeah. What's that?
Sony, I believe they accept their called VMX, and users or people who bought the VMX were using it to record TV shows and movies with their player. And so those who were having their IP basically recorded for personal use, such as the studios, Universal Studios, I believe, they took Sony to court and went to the Supreme Court, and they found that since Sony was not personally contributing to the infringement, because the users were the ones instigating this, they were not liable.
Right. Right. So the idea is that Sony created the Betamax, the VHS, like a
VHS player.
A VHS player and recorder.
Not VHS.
What it was
And
a
recorders, yeah.
VMX is a prior to the
Video recorder.
a video recorder, a videotape recorder. It's called a videotape recorder, right? Not digital, like user. So they created that and allowed people to record stuff on their TV, right? So one big question in the Sony case was like, is that what people are doing at their homes? Is that copyright infringement? It's a reproduction of content. And the Supreme Court held that it is, but it's not. It is a reproduction of content, but it qualifies as fair use because it's like personal, non-commercial use of copyrighted content for home use. What they call time shifting. I want to record this soap opera that plays at 12 so I can watch it after dinner, right? That kind of stuff. And that actually is a powerful concept today as well, right? Because with the DVRs and all that stuff, right? But, so that's one thing. Fair use, personal, non-commercial use of copyrighted content was fair use in the Sony example. So, Sony created this device that allowed people to engage in those personal, non-commercial uses that are okay. Let's say there are good uses, right? But the videotape recorder also allows bad uses. So you can use the videotape recorder for good and evil. These are dual-purpose devices, right? Devices copy devices that can be used for good and for bad. You could use the same device to record a bunch of content and sell it at the flea market as well, right? So that's the challenge for the Supreme Court at that time. And the Supreme Court said, there's a bunch of literature on this, right? But it helps us think about our topic here. The Supreme Court said, listen, whenever you have a device like this one, that is, and this is a quote from the Supreme Court, capable of substantial non-infringing uses, it's capable of substantial non-infringing uses, then it's okay. You cannot sue the device manufacturer just because, if people can use it for good just because some people will use it for evil, then you cannot shut down innovation, you cannot shut down these devices and whatnot. It's like a hammer, right? You can use a hammer to build a church, you can build a hammer to kill someone. I just don't know, which is the good or the evil in that case. That's my lame joke today. So what happened? So this is what's called the Sony Safe Harbor. As long as your device is capable of substantial non-infringing uses, the device is okay. So what happened in the Napster context is that Napster tried to say, I built Napster. This is like Sony, capable of substantial non-infringing uses. And the courts, there was a big argument about whether Sony applied to Napster or not at that time. As we know, Napster was used a lot for infringing uses, right? But there were some cases of people sharing stuff that was in the public domain, for example. And they said that, you see, there's people using it for good, so I am not liable. I am like the Sony videotape recorder. So courts developed this idea, which is important. The idea is this. The idea is, well, yeah, maybe the Napster technology is like the VTR. People can use, like the email. You can use the email for good and evil. You're not going to shut down the email protocol or whatever, right? But Napster as a service, Napster is a service. That Napster is a company that because at that time, as the way Napster was designed, if you remember this, it was like a centralized system, and if you wanted to, share and look for things, Napster will help you do that. So in that case, it's like, Napster, you're not like Sony. Sony would sell the device to someone in Radio Shack, I guess, and then that's it. But no, you are with the person. You provide a service to help them out. So for that reason, you are liable under secondary liability rules. Right? And this, I think, is important to keep in mind, because rarely we have today videotape recorder-like devices. Right? The devices that we have are constantly connected, right, and tethered all the time. There's an interesting example when, the Amazon Kindle came out. I think the second version is the one that allowed for text-to-speech, right, or something like that. So there was a controversy where, some of the books that were being sold on Amazon Kindle solidly were available on text-to-speech. And some authors and publishers complained, saying like, hey, I didn't let you do text-to-speech. So because there's an audiobook market as well and all that stuff. So you had people who had a text-to-speech function on their Kindle one day, and the next day they didn't, right? So you can see how once you have a device that is connected, you can have an intermediary, or in this case a device manufacturer, sort of adjust the rules has pressure to adjust the rules. Yes.
So that's also a little bit of that is also what has been hampering people with accessibility issues from accessing materials, because the screen readers are reading that, and then now they're not. And so they're saying that it can't be, but they need to be able to read it in order for someone to have full use of it. But that seems to be what's been dragging every single decision that the copyright has been doing, and I'm wondering, how do we go about solving that issue?
Yeah, so in that example that I just gave about Amazon Kindle, the argument was made by, I don't remember the organization, but it was an organization for people with visual impairments and blind people, who were saying exactly that. It's like, do not disable this feature. This is a good feature for us. In the end, Amazon, made its like cost-benefit analysis, and they did make the decision that they had to sort of renegotiate that with the publishers and so on. So just to answer quickly your question, in the United States as well, there's some provisions for compliance with American with Disabilities Act, so that libraries, for example, can do certain things without liability in terms of making certain content accessible to people with disabilities without fear of liability. So there's one big provision there for libraries that allows for that. And also fair use and fair dealing in many contexts as well allows for certain uses of the works to transport them into formats that can be used. So this is who we are, right? Let me jump ahead a little bit. Another rule. So what are we saying right now? Where are we? That pre-DMCA you have the following rules: vicarious liability if you have the right of ability to control and receive financial benefit, and then you can be secondary liable. Contributory infringement if you have knowledge and materially contribute to the infringement. Then you can also be exempted from those rules according to the Sony Safe Harbor if your device is capable of substantial non-infringing uses, like the videotape recorder, unless you're Napster, unless you're a device that is connected, you might be held then under rules of liability. And then you have another rule which developed in the United States Supreme Court in the Grokster case, which is the inducement rule, which is this. You can be, as an internet service provider or an online service, you can be held liable if you are inducing people, if you are sort of like promoting people, like to engage in copyright infringement. And this is what happened to Grokster. Grokster is this successor to Napster. Once Napster declined, Then you had peer-to-peer file, more decentralized peer-to-peer file sharing services. And Grokster and Casa, remember Casa, they were set up as well. And in doing the litigation, it was found that they were actually encouraging people. They said, "Hey, you lost Napster. You were not. Come use our service so you can continue sharing music." Da, da, da. So that was found by the court to be activity that was inducing people to engage in copyright infringement. So they were liable for that. Okay. So those are the default rules. As you can see, yes. Microphone.
The question I have is, all these things that are happening, that they turn off the services, what happens if those servers are outside the United States? Will that apply?
We can get to that a little bit. We talk about short answer, and then we can get to that. Just so that this depends on the jurisdiction. Like courts need to have jurisdiction over the physical, equipment, right, or the companies that are, if you don't have jurisdiction, then you don't have any legal authority over someone you don't have jurisdiction of. And the concept of jurisdiction in the legal world means that a court has power over someone or some company so that its judgments can be made effective. So maybe the servers are somewhere else, but if the company or the individuals are in the U.S., then they can be made, they can be made to manipulate whatever's going on elsewhere. If the servers and everything else is, far away, then content owners will have to go somewhere else to try to tackle that. Yeah.
A couple pieces that relate to that one as well. So did Grokster decentralize the model so that if peer-to-peer was peer-to-peer truly, and they weren't supporting the customer in finding the content,
Exactly.
but they screwed up by advertising?
Exactly.
Okay.
That's it.
And then, related to that question, if you house the base 51% of the company, the controlling aspect of the company, in a country that doesn't comply or doesn't have to comply because they're kind of outside the authority, then can't they get away with it there?
Well, it would depend. It would depend. I can't say based on that example, but if you have enough assets or individuals that are under your jurisdiction, if you have an order against someone you have jurisdiction over someone, and that person does not comply, then there are other remedies courts have to compel you to do that. So your specific question about like
if a Russian company did it and Americans were using it.
right. I don't know.
Yeah,
I have to. Yeah. Okay. So.
Just thinking about starting a company. That's the one.
Just ask the whole management.
Okay, yeah. Too late.
Okay, so so this is what. So you can see how these rules sort of, like I said before, create all sorts of incentives for online service providers. And I'm talking about internet service providers, like that but also other sort of online service providers that maybe, think about YouTube, right? Think about YouTube. Like YouTube lives, like it's the whole thing depends on content provided by other people, right? Which in many cases is unauthorized content use. So the question for Google, even if you are deciding, I'm going to set up something a Google-like, a YouTube-like service. I'm going to set up something like that. The first thing you will ask is, am I going to be liable for whatever people are doing here? Because if I am, I'm going to do other things, right? I'm not going to get into that. And if you have rules in place, default rules that are murky, like the ones that I mentioned, like if you have knowledge, actual knowledge, or you should have known of something wrong happening based on some sort of notification, and if you don't act, and you are providing a material contribution to that behavior, you might be liable. You're going to say, maybe I'll do something else. So it is and it was deemed in the best interest of sort of like the stability of business and business development in an online world, to have some sort of clarity and stability in the system And this was done through the Digital Millennium Copyright Act. And this is what the DMCA does. And I'm going to fast forward to this because shorter time. The DMCA talks about 4 kinds of institutions. Transitory digital network communications, these are ISPs, institutions that just manage traffic. System caching, which is like the first one, but like if you sort of host content as part of an automatic process, like, you know, that's also covered in the DMCA. Then the letter C is about information, like services that have information residing on systems at the direction of users. This is YouTube. It's YouTube, systems that host content at the direction of users, right? And then information location tools, this is search engines. This is Google, right? So think about the letter A is ISPs, letter B is YouTube, or even Facebook, or, you know, other services like that, and search engines. So what the DMCA does is the following. It says, okay, you guys, you are gatekeepers. Like, you manage traffic. You allow people to do a bunch of things. I'm gonna give you a gift. The gift is this. I'm gonna give you immunity from liability. And you're like, great, I can do whatever I want. Hold on. I'm gonna give you immunity from liability only if you comply with certain conditions. Okay, I'm listening, right? I want to earn my immunity. I don't want to be concerned about going to court. And immunity in a legal term, in a legal sense, is a powerful thing. Immunity means not that you're gonna win a case, it's that you cannot be sued. Like if you're sued, you just say like, I have immunity. Oh, okay, you throw out the lawsuit. So you don't have to invest a lot of money in lawyers and going through the case and things like that. It's a powerful thing. So you have now a bunch of incentives to do whatever the law tells you to do, so you earn your immunity. So let's look at letter A, the ISPs, which is a big part of the thing today. ISPs, since they only, let's say, handle traffic, or that's the vision of the law, right? The vision of the law is like your engagement with content is sort of like distance. You don't host it, you just do traffic. So this is what you have to do to earn your immunity. This thing here. You have to, and this is applicable to all of them, to all the other institutions as well, but this is applicable to the ISPs. You have to accommodate, well, this is a number of things, but this is the most important. You have to provide for a policy. You have to have a policy and reasonably implemented, like a policy that you actually use, that provides for the termination of accounts of repeat infringers. This is, a key concept. Actually, there was a case a couple of maybe months ago. I think it was against Cox Network, where Cox was found to be in violation of this provision. So they lost their immunity. That doesn't mean that they now have to pay money to anyone.
Three strikes you're out?
Huh?
3 strikes you're out more?
No, this is similar to a 3 strikes, and we'll mention 3 strikes in a couple of minutes. But it's similar to, it means that you have to have a policy. There's not a lot of case law about this, but a policy means that if you get notifications from content owners, if you say like, listen, this IP number belongs, one client of yours uses this IP number and it's been downloading this thing, do something about it. And if you do not do something about it, either notify that person or whatever, and you have to have a policy about what's going to happen when you get these notifications. If you don't reasonably implement that policy, then you lose your immunity. Again, that doesn't mean that you're going to be liable. It means that you lose your shield.
Yes, domain name registries, we go through something similar because we have registered domain name that may or may not be used for an illegal activity. Consequently, in the registrant's user agreement, we make sure that we stipulate that you can use this domain name for this particular uses, but at any moment that you decide to use this domain name to affect someone, to badmouth someone, or to do anything like child pornography or anything like that, we will delete that domain name immediately. So would you agree that registries and possibly registrars will fall also under that ISP clause, that number 8?
I am not sure. I am not sure if you would fall under letter A. I would because the definition, I don't have the definition with me right now of those like. It might be, or maybe you fall on the letter C, which is like you hosting content at the direction of someone else. It's an interesting problem.
I guess we need to go to one of those bars that you were mentioning.
Yes.
To discuss this further.
Yes, my colleague of mine says if this were legal advice, it would be followed by a bill. But it's not. So, yeah.
Since there is a termination here,
Right.
does it mean that this rule simply says ISPs should monitor the traffic figures?
No. This is a great question. Because there's another provision, which is in my next slide. It's this one, that says, nothing in this section shall be construed, it should be interpreted as saying that a service provider has an obligation to monitor its service or affirmatively seek facts. This is a critical provision in the law. It only says you need to have a policy for termination of accounts of repeat infringers. How do you learn about those repeat infringers is another business. It doesn't tell you that you have to go out there to affirmatively look for infringers or not. You can find that out because you are a good guy and you want to make sure that you have a good service, and or you work with content providers so that you establish a system so that they notify you of bad behavior, and then you sort of act upon it. For example, and this is something that we're going to talk about, I was going to mention it in the end, but it's a good place to do it. So now in the United States, and this is also happening around the world, one of the big tendencies is private, sort of like private governance, like private ordering of these things. So that, for example, big content providers in the United States have gotten together with big ISPs. And they have an MOU that's been signed, which is similar to a three strikes thing, in which these people, they get together and they have established a system so that and this is geared toward BitTorrent downloads and things like that. So that if you identify IP addresses that correspond to your ISP, then I notify you, these people, they've been downloading these movies and this and that. So according to this MOU, then the ISP has an obligation to do certain things with that user. And those certain things are, you have different levels of escalating actions. First, a notification. Second, another notification of another instance. If there's another instance, you notify again. Then there's another, so if you don't respond to those things, then there's other sort of mitigating measures of some kind, where you can say okay, you've been caught doing this, please acknowledge that you read this and you understand what's going on. If you continue, there's another measure that says you will be suspended for a couple of weeks, or your traffic will be, slow or something, and you have to go to copyright school, go look at a video and learn about copyright. And there are certain things that it might escalate into termination, right? The theory is that once you start with the notifications, people will okay, the majority of people will sort of deal with that. And this is a great example of regulating individual behavior through gatekeepers, right? It's so hard to go after the user, you just go after or just recruit the intermediaries. And why are intermediaries doing this? Why do they do it like ISPs? They do it for a bunch of market reasons, goodwill reasons, they want to be good citizens, let's call it that way. but also because it says, the DMCA says that you have to have a policy for terminating accounts of repeating infringers. If you don't have that, so if you don't play ball, essentially, you might lose your immunity, and then you expose yourself to those rules of secondary liability, the old ones. The knowledge and material contribution, right, or the right and ability to control with direct financial benefit, those things that are for lawyers, you expose yourself to that sort of legal battle. And that's what you want to avoid, right, if you're an ISP. So all these rules, they sort of create, what's the question? All those rules create incentives for ISPs to play ball, yes.
Okay, I'm trying to understand, since I don't come from a legal background and this is
Yes.
new to me. DMCA applies also to search engines, right?
Yes.
Okay, with that being said, I'm quite confused in the liability aspect. When Google was found out that they were kind of in their algorithm putting their searches favorable articles of the candidate at that time, Hillary Clinton, where they weren't liable, right? Or
That was that because here we're talking about that might be something that let's say frowned upon, right? In terms of like if you're a neutral, if you present yourself as a neutral sort of service, then you know it might be a problem not from a legal like copy, because that's not an intellectual property liability problem, right? Not a problem in that regard. Well, now that you mentioned Google, it lets me talk about another thing, which is this. So this is ISPs, right? This is their obligation to have a policy of this kind. There are other stuff, but this is the main thing. Other online service providers, non-ISPs, such as YouTube or Google, they have other conditions they have to comply with. They have to go the extra mile if you want to earn your immunity. So one of the things that you have to do is, and I'm going to skip a couple of things, is to comply with a provision in the section in the statute that talks about notice and takedown. My time is almost up. Notice and takedown. What is a notice and takedown regime? It is very simple. It's like this. You are Google. You are a search engine, or you are an entity that hosts content like YouTube. If you get a notification, and it's not any notification, it's not a simple email, then I'm just going to show this to you so you can be impressed by the number of words, right? This is the element. These are the elements of the notification, right? So you have to get a notification from a content owner specifying a bunch of things. This is the piece of content, the intellectual property that I'm concerned about. This is the link where it's at. A bunch of information. Once you get that kind of notification, then you have an obligation to take it down. If the notification is faulty, you don't have an obligation to do anything. Then you only have an obligation to take it down if you get the appropriate notification. But these are the rules that the DMCA sets up. Once you get an appropriate notification, you take it down. Then what you do is that if you are YouTube or you are Google, well, you have to notify the person that, if you are YouTube, you notify your user saying like, I took this down because someone sent me a notification. And then that person has an opportunity to present a counter notice and say like, hold on a minute, I'm good with this. I have permission, this is fair use, this is mine, that person is lying, all kinds of things, right? If that person serves a counter notice and some days go by, then YouTube brings it up again. Unless that person files a lawsuit. If that person files a lawsuit somewhere else, then you have to keep it down. But you can see how, what the role of the intermediary here of Google, in this of YouTube and Google as well in this case, is like a traffic police officer. I got a notice, it checks out, I'll take it down, I notify the other person. If the other person does not send another notification, I will leave it down. It's down and that's it, right? If you do all that stuff and you're YouTube, you retain your immunity, which is what you want, right? So there's other stuff that I will not get at here, but you can see how then the DMCA creates a sort of like procedural set of mechanisms so that authors and content owners have a way to like deal with unauthorized use of copyrighted content and manage the thing with the intermediary. And the intermediary has a clearer set of rules available so that they can go, along their business without fearing liability. Let me skip to a couple of things here before we wrap up. There are alternatives to the DMCA. I said that it's a very popular structure. One alternative is like Chile. Chile has a system where they have a notice and takedown regime as well, but they made it so that in their law, there's in the local law, the notice has to be by judicial authority. So you would have to go to court if you are a content owner and say, this is copyright infringement, and the court says it is. Now you can send that to the intermediary so the intermediary takes it down, right? So that's this is really more robust in terms of like guaranteeing that the content that's being taken down, it's actually, illegal use. Of course, that has administrative costs in general, like if you're dealing with a bunch of infringement, then going to court every time is complex, but is their way of doing it. So in Canada, on the other hand, they have what they call not notice and take down, they have notice and notice, where you just send notice and notice and notice, and then the content owner always have the option of going against the individual user. But the point here is you don't make liable the intermediary. And the obligation of the intermediary to retain their immunity is to comply with the notice and notice requirement. That is another way of looking at it because it tries to create a balance of protecting intellectual property on one hand, and on the other hand, she had her hand up first, I'm sorry, over there. Protecting intellectual property and at the same time avoiding taking down content unnecessarily. Yes.
So I just wanted to say really quickly, I run an ISP in Canada,
okay.
So I have to fulfill notice and notice. And it sounds a lot better because you've taken us through this really extreme thing about, to me it seems somewhat more extreme. But the one thing is that the notices that we are required to forward often contain sort of threatening or erroneous information. And so then we're required to forward it by law, but we can't change the content. So I just wanted everyone to know that.
So I run an ISP in San Diego for Native American tribes, and we get information from where we get our wholesale bandwidth from. So that provider sees somebody doing illegal download and then notifies us. And then does that apply exactly the same here, where we have to monitor our customer and then shut them off?
You have
So it's an end user, like somebody at their house is
downloading the ISP.
Yeah, and where the ISP.
And what is your request when you have the letter, or they have the notification? What is
So the notification that we received from whatever provider upstream says this is a notification that somebody is illegally downloading content that is copyright, blah, blah, blah. Just it's an awareness thing, and they just keep sending that notice.
Well, you should then.
And internally, then what?
Then what the DMCA Section A for the ISP says is that you have to have a policy,
which we do,
for terminating account of repeat infringers. It doesn't spell out exactly what you have to do, but the practice will be to notify that end user and say, this is what happened. We're gonna, if we get another notification, we might take action. And so you can define what those actions are. You don't have to shut down. But at some point, repeating infringers is not defined. At some point, that's have to be on the table.
So we have a policy of what to do with them, but we don't have a good infrastructure to find them because they're showing us an outbound gateway number, and we don't have it all mapped. So we just kind of play loosey-goosey inside the network. Anyway, so we should be finding out who that is and
you should
giving them a notice.
A little bit, just to be able to claim at some point if you have to.
Okay.
We're playing by the rules. Okay, just to wrap up, and I know we're out of time. Two things. One is that someone mentioned the three strikes. So the three strike system in France, for example, the Hadopi law, was a system that is similar to what we're talking about with more structure. This is what they call graduated response, which is, you take measures progressively until termination of an account or even banning someone from using, having internet access and things like that. That was a failed experiment in France. It was criticized and it went to court, and it was vulnerable on freedom of speech grounds as well. What I mentioned also in the United States, like from a private ordering perspective, something similar to the sort of like six strikes, I guess, right? Like different set of like notifications that can be used or are used by many ISPs to notify the users of their behavior. So this is more or less the landscape in general that I wanted to present to you. I know we're out of time, but we've handled many questions throughout, so if you have additional questions. But one thing I want to tell you, I know you'll have this, I have other stuff to tell you, but you'll have in this presentation at the end, you have two links at the end. You have an article by Graham Dinwoody. It's called A Comparative Analysis of the Secondary Liability of Online Service Providers. If you are really into this and you want to learn more about that, this is an excellent article. It's pretty recent, it's comparative, so it has like, what's in Europe, in the United States, in different places, so that's a great resource for you. Also, there's a link there, it's in red, so you can't really see it right now. But it's my website. I have a web for my classes and things like that. I have a link for publications, and I have some articles in Spanish. One is translated into English that deals with intermediaries as well. There's other stuff that you might find interesting. You can also contact me through there as well if you have any questions. I'd be happy to entertain your questions. Okay, thank you so much.